Okay, in the matter of People versus Eric Martin. Mr. Martin, can you hear us?
Yes, could I get the case number of the so-called case that never was given a copy of the ticket by the police officer, which he should have in violation of my due process right?
241-388 SM.
241, what else?
38 SM.
38?
1388 SM.
24138 SM. Right?
Yeah, 2 weeks.
Okay. All right, thank you.
I do have in front of me a complaint charging with domestic violence violation of city code. It's misdemeanor. Oh, I see, January 24th, January 10th. Okay, you pleading not guilty, Mr. Gazicki?
That's John James Gazicki. Mr. Martin expressed his right not to be represented by a court-appointed attorney. He wishes to represent himself.
Okay. Is that right, Mr. Martin?
Present myself, yeah.
Okay.
Because I don't want to give up my right to be one of the sovereign people, as the U.S. Supreme Court said I have a right to be. So.
Okay. I'm going to let you do that. I don't care why. Have you talked to the prosecutor?
No, I have not.
I want you to get the prosecutor and have her talk to Mr. Martin, and let's see what we're going to do today.
Right, so I would like to talk to him right about how the case should be dismissed based on there's no evidence.
Hey everyone, welcome back to today's video. We've got a packed lineup with 5 different hearings, all tied to a few ongoing sovereign citizen courtroom sagas. First up is the living man himself, Eric Martin, a familiar face who's been popping up all over Michigan courts. He's racked up multiple traffic violations across the state, and on top of that, he recently landed a domestic violence charge. He's been in custody for a little over a month now, and these new hearings give us a clearer look at how his situation continues to unfold. So with all that on the table, let's jump right in and see how today's updates play out.
A matter of People versus Eric Martin.
Okay, thank you.
Mr. Martin, can you hear us?
Yes, I hear you.
Okay, Mr. Prosecutor, you want to put your appearance on record?
And good morning, Your Honor. Or good afternoon, Your Honor. Omar Shah on behalf of the people, PA 6332.
Okay. You've had an opportunity to talk to Mr. Martin?
That is correct, Judge.
Been able to resolve this matter?
Judge, there is no resolution on this matter. I had an opportunity to speak with the defendant in this case. He wishes to have a jury trial or a bench trial. He just doesn't know which one he wants.
Okay, Mr. Martin, which one do you want? I'm going to set this over for a trial. You want a jury or the judge to hear it?
Well, I don't really want to answer that question. I don't want to be fraudulently presumed I'm consenting to any of these proceedings. You know, I'm not consenting to have my right against slavery violated by consenting to any proceedings. So that's why I kind of want to answer that question. But before I get to, as I notified the prosecutor, he should have dismissed the case due to lack of evidence. But I had one more thing I wanted to point out to the prosecutor. I forgot to mention to him. I want to mention to him now, and that is I want the police officer, Bardaway, who illegally arrested me. I want him charged for the legal arrest, which is assault and battery. And also Judge Shackleford, who did not give me personal bond. I want arrested too for violating my right against kidnapping and allowing this unlawful incarceration of me, which I have a right to do. And if they refuse to do it, I'm also going to move for dismissal on the case because it's violating my right against equal protection, because I have the right to have charges brought against people who have committed crimes against me also.
He keeps insisting the prosecutor has no jurisdiction over him, but that's exactly what the trial is meant to sort out. And let's be honest, if there truly were no evidence against him, like he claims, we wouldn't even be this far into the process. His own alleged victim wouldn't be sitting right there in court either. At one point he stepped into a breakout room for a private discussion with the prosecutor, but as expected, nothing productive came from it. He walked out repeating the same line, that this is all a malicious prosecution, and that the state supposedly has no authority over him.
Okay, based on that, I'm going to indicate that you want a jury trial. I'll set this matter over. I'll have the assignment clerk set a date She'll send you a notification of the date for the jury trial. In the meantime, I'm gonna continue your bond until that day. You go with the sheriff, he'll take care of you today.
Hold on, objection. I have a motion to make that I have a right to a personal bond.
You
I have-
file that motion in writing and I'll take a look at it.
I already
In the
did file it with
meantime, in the meantime, I want you to go with the sheriff and he's gonna take care of you.
Hold on, object. I have some, I already
Put 'em on,
filed it with the
put 'em on
I'm
mute.
making that motion now. I'm making that demand actually now because it's a constitutional right to be
Denied,
presented without guilty.
denied.
All right, then I'll be taking your job. How about that? Because you violate my constitutional right and I move to dismiss you off the case, disqualify you. Since you violate my due process right to a personal bond, then you showed your biasness and you should not be in the case no more. I move to disqualify you. If you deny that motion, I request that you send it to the State Court Administrative Office. You're not supposed to continue my bond with monetary award. Shackelford illegally denied my personal bond, and you're not supposed to continue that illegal denial. I have a constitutional right to be presumed innocent, and that means the right to a personal bond. Article 3, Section 1, judges that violate the Constitution cannot hold their office. So don't grant that motion if you want to, that demand. I'll be to get your job in a lawsuit. That's all I got to say. So you want to continue with that? Sound like they muted me, maybe. Well, these judges are going to find out. They're not above the Constitution.
Crimes have to be real, not imaginary offenses you've invented to avoid responsibility. So let me make sure I understand what you're asking for here. You want the officer arrested because he arrested you. You want the judge arrested because you didn't get the bond you wanted. And to top it all off, you're suggesting we arrest your own victim apparently for the crime of her face coming into contact with your hand.
This is case 231510, people of the city of Taylor versus Eric Martin.
Jeffrey Fanto, the court asked me to verify that Mr. Martin would be presenting himself without the assistance of attorney. That appears to be his position, Judge.
All right, so Mr. Martin, you are waiving the House Counsel?
Yes, so I'm not fraudulently assumed to be the defendant, a living man, not the legal fiction corporate entity defendant, which I couldn't possibly be. I know due to canon law being, unfair, it's gonna, you guys fraudulently assume that if I take an attorney. So that's the unfairness why I can't accept attorney because of that.
Sure. All right, and you understand all of your constitutional rights?
I do my best to. I've been studying, practicing law 28 years.
All right, that's all right. So looks like this is ready to be set for a jury trial, is that right?
Yeah, but I want a jury trial of my peers means of the sovereign people, not U.S. citizen slaves who most probably everyone of the jury probably say they are. So.
Didn't you just claim to be a 28-year constitutional law scholar? Because if that were true, you'd know by now that a jury of your peers is made up of actual citizens, not the buddies you sit around a campfire with melting crayons for fun. It's hard to take that title seriously when you're still misunderstanding one of the most basic principles of the justice system.
As the individual who determines questions of law, that's me, I will make sure that it is a jury of your peers. So, and I'll determine that. So we will have this set, and then I'll mail out the date for the jury trial.
I believe is a date set for next Tuesday for the jury trial in this matter.
All righty, I see that.
I have objections. I cannot probably prepare for trial in this jail. I've been illegally denied my constitutional right to a personal bond, even though it's my constitutional right because it's part of my right to be innocent before guilty. It's been denied so far. I have no money to pay for a bond to get out of here. So that's especially why I also should be given a personal bond. And like I said, I cannot probably prepare for one in here,
So you're in there for a different matter, because I set your bond at $100 personal before on this matter. So it's whatever's keeping you in jail isn't this case. So we'll see it. I I understand though that you do need to prepare for trial. I get that part. So we'll go ahead and adjourn the jury trial. When is your out date, with whatever you're doing there?
There is no out date. That's the thing. It's so is this about the moped case?
Yeah, this is driving while your license is suspended.
I wasn't sure. Right, they got me legally confined right now in the domestic violence. No evidence at all. She lied, made a statement. So now they
Hold on, Mr. Martin, hold on. Even though this is a different court and that's not my case, you have the right to remain silent. Anything you say can be used against you. I just want to advise you of your Fifth Amendment right again. And so I suggest like not bringing up the other case. This case here is on the moped and the driving on a suspended license, or a revoked license.
Okay.
So what I'm saying is you need time to prepare on that one. I don't know what the situation or status is of the domestic violence case, but you said that you're on bond. You haven't posted your bond on that case. Is that what you're saying?
Well, I'm not even sure. I think the judge said a monetary bond. I wasn't sure because she unprofessionally drew the thing away from, you want to call it this, the remote Zoom thing away from the door before I could read the hearer. But it sounded like she told the police officer $2,000, but I'm not even sure. I got no money to pay a bond, no way, even if it's $1. So.
Well, that part about being too broke to afford a $1 bond, that's actually true. You are a sovereign citizen, so I'll give you that. But everything else you just said, complete fiction. I was at that hearing, and I have the video to prove it. Judge Shackelford clearly explained exactly what your bond was and why it was set at that amount. The camera only cut away after your bond was finalized, and only because you wouldn't stop causing a scene with your antics.
Judge Shackelford very clearly told you what your bond was and why it was that amount. The screen was only pulled away after your bond was set, and only when you wouldn't stop running your glue eater.
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordered that. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
and he's not to
return.
Personal
bond.
He's not to appear at 9.
Innocent without guilty.
He cannot come to 9074 Clifford or be in contact with Crystal Martin.
So, right, because they illegally deny my personal bond, this is why I'm still in here. So, but yeah. So,
all right. So what I'll do is, I don't know when that case is next. The next day, is that it's a state case? Ms. Manarino, you don't have that case, right?
I don't know.
So it must be a state. All right, and so it must be a state case, which means it's on a Monday. So that's probably going to be resolved within a month. So let me go ahead and set this for jury trial. No, there will be no need to set it for a settlement conference before that. But let's get a date.
I won't catch up. I was going to object before you guys don't give me a chance to talk. Object to it should be. I moved that to be stayed. This moped case till I get out of prison. Till I get out of jail here. I can prepare myself. I can't probably prepare myself.
Right, that's right. Listen.
Ask some of my legal authorities to argue nothing.
It's being set for a jury trial.
Good one.
From yesterday.
Okay, so when is that one?
They didn't set it.
Okay. All right, so I'm going to set it for a jury trial, but if you're still in jail at that time, then I'll just adjourn it again so that you can prepare. I'm not worried about that. So, but I can't do anything about your other case is what I'm saying. So I'm looking at, as far as a date right now, I just want to put a date on the books so that we know that you have an idea. If you get out tomorrow, then you'll know and what your date is. So I'm looking at, let's see. And I don't have the availability to check with my clerk because my criminal clerk is out this week.
Your Honor, we do
I'm
sorry, Judge. We do have other jury trials scheduled on your docket on July 9th. I don't know if that's too soon.
That's probably going to be, and it's only a couple weeks away. So I don't know what his situation is. And even if he gets out in a week, that only gives him a little bit of time. I want to make sure he has at least a couple weeks to. It's a driving. it's a driving on a restricted license, so it's not exactly a whole lot of prep time for that. It's not a homicide case, but
Don't even get him started in sovereign citizen logic. Driving without a license is treated the same as serious crimes like homicide. According to them, both are victimless offenses, which means, in their eyes, nobody has the authority to prosecute. Of course, that's completely at odds with real-world law. But in their world, jurisdiction simply doesn't exist for these crimes. It's a classic example of how their arguments clash with actual legal reality.
so I'm looking at August 13th. Because I'm trying to pick a date that's outside of probably where I'm already scheduling stuff at, because I don't have my criminal clerk here to kind of check and see like where I'm at with things. So we're gonna set this for August 13th.
Thank you, Your Honor.
And I know that we'll set that at 8:30 in the morning, August 13th. All right. Mr. Martin, let the deputy know that you're all set, and we'll be mailing out the notice to you, sir.
Thank you, Your Honor. All the best to you and your staff.
Say again?
That's something I want to say to, okay, with the prosecutors here. Dealing with this other case that I'm here for now, I request that.
Not the same prosecutor. Not the same prosecutor. That's the state prosecutor.
They're Taylor prosecutor.
Your other case, are you talking about your other case? Your other case is a state case, so that's a Wayne County Prosecutor's Office.
No, sir,
not the city attorney.
I'm talking about
Okay.
the case I'm in here now. I want them to notify the prosecutor that I want charges filed on Crystal Martin for bringing these falsified charges against me now. And also for assault and battery that I have on video camera for. Just so, you know what I mean? And she keeps bringing this.
Again, that's the other prosecutor. That's a different prosecutor's office, sir.
Because it's my equal protection right to bring charges too. They want to bring charges against me, but they don't have no evidence. I do. And I should be the one suffering here in jail as a lack of evidence. This is all pride and the unequal protection clause.
And that's on your other case, sir. So,
It's still a right though. It's still my right to tell the prosecutors this and have them act on it. And if they don't, it's going to certify a defense.
This isn't the proper prosecutor. That's the Wayne County Prosecutor's Office on your other case, okay? This is the city attorney. Okay. Deputy, have a good rest of your day to you and your staff.
Thank you, Your Honor.
Thank you, Your Honor.
All right, that wraps up this hearing, but he had another one just yesterday. And let me tell you, I've never seen anything like it. In just 3 weeks, this guy looked like he had aged an entire decade. Court life, or maybe the stress of his own antics, seems to be taking a serious toll, and it's hard not to notice the change in just such a short time.
McMullen, case, the motion to set aside. Let me bring them up. People versus Martin, case 241388 SM. Today's the date and time set for a settlement conference. Also, there was a motion by Mr. Martin, motion to dismiss the case. Court has read through the motion. There was no accompanying brief in support. Well, there's also objections to the denial of the personal bond. I'm going to consider that as a motion for reconsideration. All right, Mr. Martin, was there anything else you wanted to place on the record, sir?
Oh, yes. Well, first, I'm not the fraudulently assumed defendant. I am a living sovereign man.
I can see that you are a living man. You are currently talking, and we are having a conversation. So, okay.
Right, but John, under the law, there's fraudulent presumptions under canon law 3228 that, you know, that say otherwise, and there's a lot of support what I'm saying. So that's why I say what I say to, you know, for the record. But anyways, yes, I do have other things to say. First, I also want to file a demand to dismiss this case based on speedy trial violation under Mission Court Rule 6.04C, 28 days for speedy trial in misdemeanor cases. I've been in jail over that since the 8th of last month.
It takes a special kind of audacity to make a legal argument and immediately undercut it in the same breath. Here's what's happening. Speedy trial rights are meant to protect defendants who are currently in custody, and technically, he's correct under MCR 6.4C. He should be released on a PR bond after 28 days, unless the court can show clear and convincing evidence that he's a flight risk. But here's the problem. He refuses to acknowledge the court's jurisdiction, has skipped multiple hearings in the past, including right here in this courtroom, and has openly admitted he doesn't feel bound by the law because, as a self-proclaimed sovereign, he believes the rules don't apply to him. By that definition, he's a flight risk, plain and simple. And in the end, MCR 6.4C just doesn't apply to...
And also, well, go ahead, and I also want to say, I ask that you give me all the time to speak, say anything I want to say, instead of like shutting the court proceedings off that's happened before, make sure I'm done with everything I have to say, but that's it for right now. But like I said, I might just say, depending on what you say in response. So.
All right, well, your motion to dismiss is denied. Your motion for reconsideration with regard to personal bond is also denied. Are we setting this for a bench trial or a jury trial?
Before I ask that question, I have to respond now to your denial. Now, based on what reasons are those denied, I have things to say in response to that.
Well, sir, I'm not cutting you off, but there's nothing, it's my ruling. If you want to file a motion for reconsideration as to anything, you're more than welcome to follow the court rule and do so. But there's really nothing to add to my ruling. So
I'm just asking the reason. I'm not asking what are the reasons that the bond, for example, is denied? Okay, first of all, what reasons is it being denied?
I've already stated that last time, sir. So are we at the next question here is, do you want a bench trial or a jury trial?
Well, I have more to say in response to
do you want a bench trial or a jury trial, sir? Stop avoiding the question.
I just want to take off jury.
Jury trial. All right, we're going to set this for a jury trial.
But I want to make it clear, I'm not consenting to
given notice. You'll be given notice of when that will be, sir.
Okay, I'm not consenting to the jurisdiction of the court still, and
Do you see the contradiction here? You openly refuse to acknowledge this court's authority, yet you expect the judge to declare you not a flight risk and release you without any conditions. It's a classic example of asking the system to bend the rules for you while simultaneously rejecting its power and, unsurprisingly, that just doesn't fly in real-world court proceedings.
You are subject to the jurisdiction of this court. So you live in the state of Michigan, you live in the jurisdiction, and under the Michigan Constitution and the United States Constitution, this court does have jurisdiction over this case and over you as the alleged defendant. The warrant was signed with probable cause. The warrant had probable cause. The warrant was signed. That's all that's needed to bring a charge, and it's brought in the proper place, which is here because you live in Taylor, and this is Taylor, so this is where the case would be. So your motions were denied, and we're going to set this for a jury trial. We'll be giving you the date and time of when that jury trial will be. Let the deputy know that.
That's what I mean. See, I'm not done yet. I have more to say.
Oh, come on, he wasn't done talking, and we definitely had more popcorn-worthy moments to witness. But that wraps up the Eric Martin saga for now. He's not going anywhere, and for the record, no speedy trial rights have been violated. Next up, we're switching focus to a different sovereign citizen, one I haven't covered before. Other channels like Old Squishy, Gardner, and Colin have touched on him, but he had another court appearance late last week. I figured it was worth covering both hearings. A recap for anyone who missed the first one, and an update for those following the latest developments.
Versus Coon, case number 235256.
Sierra Coke on behalf of the people.
Mr. Coon is present here in the courtroom today. This was originally set as a sentencing hearing. Mr. Coon, I got a report from the probation department indicating that you can find to participate in the investigation process.
Up here. Greetings, Your Honor. I'm here by special appearance, not a general appearance, and I reserve all my rights and explicit reservation without prejudice. I, Paul Coon, a sentinel moral being, have examined the path of my feet on and have concluded that I have dishonored many people, including, but not limited to, the people, the peace officers, the city, the county, and to determine that I have made many mistakes, and I'm sorry for my sins, and therefore I repent now. I have become aware of other sins I may have committed, and I'll repent immediately.
This isn't a church sermon. We don't need a confession or a repentance speech. What the court does need is for you to take responsibility for your actions. That means cooperating with your pretrial investigation so the judge can determine whether any jail time is necessary and whether you even qualify for probation. Refusing to participate won't protect you from consequences. In fact, it almost guarantees the exact opposite.
To my attorney, it has come to my attention that you have never informed me of my choice of law. And to make matters worse, you chose an inferior form to have me tried under. You are either incompetent or collusion with the prosecutor. Either way, you have provided me with an ineffective assistance of counsel, which has caused me great harm. You are fired.
Okay. Do you intend to hire another attorney? Are you appointed?
I was appointed.
How are you going to proceed in terms of counsel, Mr. Coon?
Oh, I'm going to do it myself.
Okay. All right. You understand that you have the right to have an attorney?
I do.
And you understand that if you can't afford an attorney, you have the right to have one appointed for you at public expense. And in fact, that's what we've been operating under up till now.
I haven't gotten legal counsel, but anyways, I'll accept whatever you have.
Okay, so you understand that you do have the right to have an appointed attorney if you can't afford one?
I had him and he has done me no good from the beginning. So
yep.
At this point, I'll just I'll take whatever you got to give me.
Well, that's definitely a bad move. At the very least, having an attorney present means someone can argue that your nonsensical claims are the result of internet-fueled confusion, not a deeply held belief system that requires jail time to correct. Without that professional perspective, your arguments come across as nothing more than rambling, and the court has no reason to treat them any differently.
I'm just asking whether you understand that you have that right.
Yes.
And in spite of that, you're asking the court to allow you to represent yourself today?
Yes.
Okay. Have you ever represented yourself in court before?
Sir, I'm here as a special appearance only, and that's.
Yeah, that doesn't have any legal significance to me at all.
I understand.
My question is whether you've ever represented yourself in court before.
No.
Okay. Do you have any legal training or education?
No, just have the people that help me through this.
Okay. And so you understand that there are, not having represented yourself, not having any legal training or experience, that there are risks involved in representing yourself?
Yes, sir.
And that there are matters of procedure and substantive law that you may not be aware of, and therefore there may be arguments that you could raise in your own defense that might give you an improved outcome in your case, and that without that legal training and experience, you may not know what those are, and you may have a worse outcome than if you had an attorney.
I'll take what is given to me.
In spite of those risks, is it still your wish to represent yourself?
I'll take what is given to me.
That's not the answer to my question. My question is, do you still want to represent yourself knowing those risks?
Sir, I just I'll accept any offer. In return, your offer to for your closure and settlement of any account I may have.
Okay, again, my question is, in spite of the risks of representing yourself, are you still asking to represent yourself?
Yes.
So at this point, the court, with Mr. Gurmurthy will discharge you. The court finds that your request to represent yourself is knowing and voluntary and unequivocal. And so at this point, the court's going to allow you to represent yourself going forward. Do you have anything to say with regard to your refusal to participate in the pre-sentence interview process?
Whatever you want to give me, I'll accept.
Okay, so that's something that you're required to do as part of the court's order. Because you declined to do that, the court is going to revoke your bond. The court is going to order that you be remanded to the Crawford County Jail. I'm going to request the probation officer to make another attempt to go through the pre-sentence interview process with you. If you continue to decline, then we'll just go forward with sentencing without having that information before the court. And Mr. Haven, if Mr. Coon refuses to participate, just indicate that for the court, and then prepare the pre-sentence report to the best of your ability without that information.
Yes, sir.
I did an acceptance, dated and signed the top of it. And that's all I'm doing.
Okay, well, we'll give it another try anyway, and you're going to do what you're going to do. But for today's purposes, the court's going to revoke your bond and remand you to the jail. The court will set this for a sentencing hearing at its next available date. So you can go with the officers, please.
Okay.
Here's one way to make someone take their pre-trial process seriously. Let them sit in jail without credit toward their charges until they accept that a jury of their peers has found them guilty. It's a harsh but effective way to make it clear that responsibility can't be avoided. Fast forward to his second hearing, and it looks like he's finally starting to accept his fate, though, of course, not entirely. There's still some hesitation, but the reality of the situation is starting to sink in.
Okay, so I just want to explain a couple things to you. That I have an obligation to ask you certain questions to make sure that you understand what's happening with your case. And that's why I'm asking you whether you understand that you have the right to have an attorney and that you would have the right to have one appointed if you couldn't afford one. I'm just trying to make sure that you understand your rights, and it's my job to explain those rights to you. I'm not asking you to give up any rights. You're not putting yourself in any kind of legal danger by answering these questions. I'm just trying to find out if you understand what your rights are and how we're going to go forward, so that I know that you're knowingly and voluntarily choosing not to have an attorney to represent you. And if you don't answer these questions that I'm asking you, it impedes my ability to proceed with the hearing in the way that I'm required to under the law. You understand that?
How to answer that. All I know is I was told, when I've read and stuff, that I'm here in special appearance.
What do you think that means?
I'm not contracting. If there's no corpus electi, how could there be a crime?